Wallach. I am a real estate attorney. I do real estate, business law, and litigation arising out of real estate and business law. I have a firm, Wallach and Associates, and I have a few lawyers working for me, so it's not just a sole practitioner situation, and it was for some years, but if anything, I'm growing at this stage, which is interesting. I didn't totally expect that. But so we're growing in what we can handle. We can handle trust and estates now, and we can also handle a wider range of litigation. But our core is still business transactions, both real estate and to some degree just ordinary, like buying and selling of a business and things like that. So we're a business law firm primarily. Today, I guess what I planned on is really focusing down on what I think is the structure that you need really in the beginning, and for many people, kind of all you'll ever need. Many of you have met, and some of you know well, a man named Dan Bryan. Dan Bryan is a great guy. Dan Bryan has the mind of a lawyer, although he never went to law school. He's quite a phenomenal guy. He's also a general contractor in both electrical and plumbing. He recommends a lot and loves to talk about trusts. I will make a passing reference to trusts in what I think is the right place, but trusts, and I help him teach that class sometimes. And so if you're ready for that, it can be a great strategy, but it's definitely more complex than you need at the beginning. And as I'm saying, for many of you, you don't ever really need to use a trust. What I'm basically going to be recommending, and I'm going to get into the details quite a bit here, is a limited liability company. Now, most of you have heard of it, I'm sure, an LLC. And that structure in Missouri is simple, straightforward, and can do, I think, pretty much everything that you need. But let's get into why and kind of why I think so. Go through some of these slides and we'll see more about it. But how many people already have an LLC? I should probably, we should all just go home then. Be kind of short. I guess hopefully then but that tells me something. I'll emphasize some things then that might have been a little deeper than I would have gone into, but I may know a couple of tricks that you might find helpful. So here. What are the original forms of doing business? Well, of course, you can do businesses yourself. It's still allowed. People don't tend to do it so much, but you can. It's sole proprietorship, right? That's the technical name of it. You can do a business as yourself and your spouse. You can even adopt a business name. And there's a way to file that in Missouri. You've probably all heard of it. It's just a DBA, a doing business as. What's the limitation of that? Anyone want to tell me what they already know? Why is that? You can do that, but what's the big thought that comes to mind if that's all you do is work for do it yourself or do it as a DBA? Does anyone want to volunteer?
No protection.
No protection from what though? Right. Well, from lawsuit, basically that you're on the hook, you own that property personally, so anything that goes wrong, right, is going to come back on your head. Somebody has a trip and fall, something happens with the property and, or you can't sell the property. I mean, everything is on you financially. So how do you avoid that? Well, people have tried obviously you can have partners. Partners do spread the risk some, right? What's the problem with partnerships though? It's the same problem, which is that you have a partner now, or two or three or whatever. So that spreads the risk some. However, you're all personally liable for the debts of the partnership. And furthermore, you now have to watch out what that partner is doing, because if that partner does something, that binds the whole partnership, or it can. We're not here to get that deep as to when would it bind the partnership and when wouldn't. We could go forever on just something that narrow. But that's a reason not to, oh, I don't know. That's a reason not to simply use a partnership. Corporations, you could use a corporation, but corporations have complexities that you don't need. And you have to do an annual report every year to the state of Missouri, which, little preview, which you don't have to do for limited liability companies. So you have an annual report, but more important, you have multiple layers of tax. Most of you probably know some of this, right? And other issues that make a corporation kind of complicated, needlessly complicated for holding real estate. Not to mention that you're going to get taxed at the level of the corporation and then taxed again when you take dividends out. So distributions from a corporation are also taxable. Now trusts, here's where I did put it in here. Trusts are a very old form. Dan loves to point that out. Trusts are, as are corporations. Both of those have been around in the Western world well before there were corporations in Europe, before the Europeans came here. So, I mean, those two forms, corporations and trusts, are very old. But trusts were not designed to protect you against liability. They are very private because there's no public filing for a trust. A trust is created by a private contract between you, the trustee, and the beneficiary. That's one thing that Dan loves about them. But, and I'll tell you what, don't ask me about QST twists unless you're really interested in trusts, so I can talk afterward about that. But trusts, so they can be useful, but they're complex to set up and they do not, in and of themselves, protect you from liability. The trustee can be liable, the beneficiary could end up being liable under lots of different scenarios that we won't dig that deep. However, limited liability companies essentially solve all those problems. What do they have in common with corporations? I mean, corporations were good in their day when that was all the only choice you really had. So what does it do for you that's positive? Everyone, it's the same answer you gave me before. It does protect you, the shareholders of the corporation, from personal liability for things that the corporation does, including if the corporation does something wrong, or there's a trip and fall on its property that the corporation owns. Well, that would protect the shareholders from being personally liable for the debts, but there's so much other complexities to the corporation. And guess what? A limited liability company gives you the same protection as a corporation. It's now well established that the protection that a limited liability company gives you is identical to the protection that a corporation gives you. What's interesting is that limited liability companies are relatively new in the United States. The first state to pass a statute that created the idea of a limited liability company was in 1995 or 96, and it was Wyoming. I don't know why, but other states soon followed. But in the beginning, people were a little nervous to use it because they didn't know would courts. The idea was that they should be the same protection as a corporation, but at first, it was considered a little risky to try it because until it was tested a few times in courts, and that's how the law is in a lot of things, right? You've all either heard of that or some of you have experienced it, that something new in the law is not always a good thing because you don't know which way it's going to go. The law works a lot by precedence, which means if it's been done before, now we know what's going to happen in that kind of case. So LLCs took about a decade, I would say, before they became widespread. So by the mid-2000s, it was becoming like just a given that they're fine. I thought it was fun to put in the fact that they are older in Germany, Spain, and France. I just picked those three because they're like the most familiar European countries, I think, in terms of if you're an American. And there was always, when you see AG after a company's name, like Siemens, that's the same as, Inc. in English. If you see, I'm hitting the buttons here. If you see that other thing though, GmbH, right? That's essentially a limited liability company. And those have been around at least 100 years. Same with in Spain and Latin America and in France. So the, Romance languages, Latin languages, it's similar. So you'll see SA, and SA in either French or Spanish is the equivalent of Inc. It's limited, Sociedad Limitada implies limited liability. The other one, Sociedad Anónima, excuse me, I got it backwards, is the one that's equivalent to Inc. And then the SRL or SARL is equivalent to limited liability company. Just a little fun footnote, but my point was that they were well established in Europe, and for a long time, American lawyers would look across the pond, as they say, and be very jealous of the fact that this existed over there, because people were trying to do similar things, and they had all kinds of gimmicks to try to make it work. But anyway, now those gimmicks have kind of disappeared into history, and we have limited liability companies. So let's get practical. There I put limited liability, no LLC, no liability for the LLC owners. And the slide is, as you all can see, is chief features. That is, to me, the chief feature. That's what you want. That's why you want an LLC. However, there are other things that are good about it. Privacy. We're going to emphasize something here that I want to teach, which is if you set up the LLC correctly, it can give you just as much privacy as a trust, as that whole trust system. It's true, the filing is public, but I'm going to go into, in a slide or two later, how you do it so that there is no issue about all the world knowing that you're really the owner of that LLC. So there's a way to do it, but there's also a way to goof it up where the whole world will know, and it's very hard to erase, right? Because we all know once something's on the internet, you can change it, but it still can be found, right? So you don't want to get it wrong in the first place. You want to do it right, but if you do it right, it's just as private. So I'm going to go into more detail on that in a minute. Beneficial tax treatment, right? What's better about the LLC than the corporation as far as tax treatment? Who here, anyone know? Or has it, to a lot of you, it's obvious, I'm sure. You could solve you're hinting at what I'm talking about and then solving it without saying what the problem is. Yeah, so it's obviously the two layers of tax I mentioned earlier in the corporation and in limited liability company is a pass-through entity, meaning it can make as much or as little money as it wants. It doesn't pay any tax directly. Now, it does have to distribute. When you're all said and done, in other words, you take the expenses and net them against what you made, and all the other things you can do to lower your taxes, to lower the appearances of income or the reality of income. But in the end, you get a K-1, you get a form that says, okay, now you're the owner of this, you get this money and you pay taxes on it, but at least you didn't have to pay taxes on it at the level of the company. You just have to pay ordinary taxes on it at the level of your own income. Escape will do it? Yeah, thanks. Perfect, it did. Now, flexibility, ease of use compared to a corporation. Again, there's no annual report. There's no, that's very unusual. In the sense that even in Illinois, there's LLCs in other states, but as far as I know, I've not run into a state except Missouri that doesn't require something to be filed every year. Missouri is unique in my experience. I haven't tried it in all 50 states, but I've tried it in multiple states, and as far as I know, you have to keep filing something once a year at least. But not here. You do it once and it's good for life. Easy and inexpensive to set up. It is relatively easy to set up and it's relatively inexpensive. In Illinois, it costs you $500. In Missouri, it costs you $50. I'd say that's a pretty big difference. Not only that, but in Illinois, you pay something. I don't think it's $500 every year. Maybe it is. Anyway, it's a lot every year. And in Missouri, you're one and done. So I've actually been as a lawyer in a position of recommending to somebody living in a different state that they form a Missouri LLC, because it could be, now there's problems. It doesn't solve everything. Because you probably have to file, at a certain point, you might have to file in that other state something to recognize the quote foreign, meaning out of state entity. It gets complicated. So it isn't always that useful to do that. But certainly while we're here in Missouri, it's a pretty good deal we have with the limited liability companies. And they are easy to set up because those of you who've done it, and I'm sure some people in here have done it themselves already, the questions that they go into are not all that complicated. And then you can do it online. Now, that's what's called the Articles of Organization, and they exist online. You also need a second document, which I'm coming to, called an operating agreement. That's a little more complicated. There's a little less guidance out there on how to do it. But and let me come to that, because I do have slides on, we're going to move through that. One thing people do not always know about an LLC, because it definitely is not talked about much, and is that you can put provisions in your operating agreement that would make the LLC transfer on death, just like a TOD on a bank account or on a car title. You can build something into your LLC that keeps it out of probate, keeps it from going to court to decide who's the next owner. It can be in the operating agreement, and that is enforceable. It will work. So that is a very useful. You certainly can't do that with a corporation. I mean, you can leave your share. I guess you can in a way. You could leave if you're the sole owner and you've got all the shares, you can leave the shares. But you can't, but you can't put transfer on death on the shares, I don't think. I don't know. I'd have to look into that, but it's certainly easy with an LLC. So what do you need to do to set up the LLC? You've got to make sure the name has not already been used. So one of the first things, if someone comes to me, a new client, what are the minimum you need to tell me to help set up the LLC if the person isn't going to do it themselves? They got to have the exact name, because we got to clear it. It's easy to do, but you have to make sure it's available, name is available. There are two basic answers to this question about member or manager, which is that you want to know whether you're going to make it a member-managed LLC or a manager-managed LLC. This is probably the most complicated question you'll have to answer, and it's not that complicated. Basically, So I always recommend, for most of the time, that you make it a manager-managed LLC. Now, why do I say that? Let's back up one step. The owners of an LLC are not called shareholders the way the owners of a corporation are. What are they called? They're the members, right? So you're called a member of an LLC just because you're one of the owners. Well, you're the sole member, then you're the sole owner. So that's kind of the default, meaning when you fill the form out too, if you don't do anything, it'll be member managed and it'll be just members. If you pick managers, you're not forced to name anybody as a manager. You could still just have one member, or let's say there's two of you and you just want to be members. You don't ever have to appoint either one of you as a manager if you decide, well, I don't know why we bothered with that. We don't really want that. Just leave it alone, then just don't do it. But it's nice to have the choice, because there's a couple different things about that are helpful, or can be. One is you can name a manager who's not one of the owners, but that manager can do things to run the company. But more important, you can call yourself, if you're at least one of the members, but you're the one who's going to run things, you can also be the manager as well as a member. Sometimes that can be very useful when talking to tenants. If you own a manager-managed LLC but it owns rental property, and your tenant is complaining to you about how the toilets don't work, or this, that, or they never do that, they never this, they never that. And if they see you, or you can basically say, well, I don't know, I'm just the manager, right? I'll have to ask the owner whether it's okay. You're just a manager. So you can put, if you're clever with it, you can put a layer of negotiation between you and, like, the buck stops with you. No, it doesn't. It's, I've got to check with the members. Never mind, you're the sole member. They don't need to know that. Well, or it could be true, right? Maybe you have one or two members that are not besides yourself. Here's where we get into the tricky part. The registered agent and the organizer. There's a line in there called organizer. The organizer is a leftover vestige from, I don't know, the 19th century or before. It makes no difference whatsoever under any circumstances who the organizer was. You could put Bozo the Clown as the organizer. It will not matter, okay? So you don't, what should you not do then, based on what I just said? No, you should not put yourself, right? Why? I mean, maybe for ego purposes, but now, guess what? The organizer will be visible on the internet for the rest of time. So, and even though you didn't say it doesn't say anywhere there that the organizer is the owner, and the organizer is not inherently an owner. The organizer has no particular rights. It's not totally perfectly true, but it might as well be, for everybody's purposes. The organizer has no particular rights, so there's no reason to put yourself as the organizer. But you can bet that people are going to assume or guess that if you're the organizer, you probably likely that you're also the owner. In fact, they may even just assume that that's what that means. So now you're inevitably connected with that company. The registered agent is a little trickier. You must have a registered agent. The registered agent has one actual job that cannot be delegated to anybody else. It doesn't come up a lot, but when it does come up, it's really important. If I'm as a lawyer, I need to sue on behalf of my client, we need to sue somebody's LLC. And we write up the court paper and we file it in court. Then either I have to find a private person or the sheriff of St. Louis, of the county, can do it also in the county where the LLC is located. But the person who's going to be served with the papers that say, hey, you've been sued, is the registered agent. It must be either an individual human being. Sometimes lawyers use individuals or persons. Persons can mean artificial persons like LLCs and corporations as well as people. But the word individual to a lawyer signals, it's like almost a code word. We know that when we say individual, we mean a living, breathing human person. And a registered agent, there's only two types. Individuals or corporations. Now, don't ask me why, but a corporation can be a registered agent. Not an LLC, not a partnership, not a trust, nothing else. An individual human being or a corporation. My law firm is a corporation. If I'm helping you with this, why not put my law firm as the registered agent or whoever your attorney is? Because first of all, who should know first that you've been sued? It wouldn't be a bad idea, right, to have, even if you don't like that lawyer anymore and you want to go to a different one, but that lawyer is certainly not going to risk his license and forget to tell you that, hey, you just got sued just today because I got served as your registered agent. So even if you don't like that lawyer anymore, that lawyer will make sure to find you and at least tell you that much. And then he or she will say, well, you want me to represent you? And you could say, no, I got a better lawyer. But at least you'll find out. What's the big plus of that? You don't appear, right? And I don't mind doing it because everyone understands that if Wallach and Associates, PC, which stands for what? Does anyone know, by the way? Stands for Professional Corporation. When you see a PC, it's only going to be like doctors, lawyers, architects, only certain professions in Missouri. This is just a quirk of Missouri law. So a PC is a professional corporation, but I am a type of corporation. That is my Wallach and Associates is. So it can be a registered agent. A lot of lawyers are just LLCs, they're a law firm, I mean. That firm cannot be a registered agent, but a PC can do it. So that, and now who's all over the internet? Wallach and Associates. Well, I don't mind that because no one's gonna come chasing me because they figure out pretty quickly, well, he's just a lawyer. He doesn't own it. It's probably his client or her client, right? I mean, whoever the lawyer is. So this is what I meant by if you set up the LLC right, it's just as private as a trust. The trick is do not put yourself, as the organizer or the registered agent. And it's not so great if you did it and then you change it. I mean, I guess I would do that if you did it. But the old one is hard. I mean, it can probably still be found. It's better. I mean, if the current one is, if you change it, it's still worth changing because it's not so easy to find older versions, but I think they're there if you really know how to hunt. So that is how you preserve privacy using an LLC, is don't put yourself anywhere in there. You don't, back up to members and managers. You pick member or manager, but nothing in the form requires you to say who the first manager or the first members are. You don't put that. Now that form is public. I guess I should have said that because I guess it was implied by what I was saying. I just realized I never really said that. We're talking about a form, of course, that gets put on the Secretary of State's website, the Missouri Secretary of State website. So that the answers to all those things you fill out in that form, the articles of organization, are visible on the website of the Secretary of State. Likewise, if you want to know something about an LLC that you're dealing with, just go to the Missouri Secretary of State, do a business search, and put the name in, and you'll see all this information. So that can be useful. And other people who didn't come to this lecture and don't know not to put their names in it, if you want to know who's really running it, a lot of times the people do put their own name, either as registered agent or as organizer, and well, that gives you a pretty good clue of who's either the owner or closely involved, at least in the business of the LLC. Then you get to financing. So the first question is the bank. You want to open a bank account in the name of the LLC. What is the bank going to ask you for? Besides money, you got to have at least what, $100, $10? Yes, your operating agreement. So that's the other document that you need to form, and that one is not filed anywhere in public, unlike the first thing we were talking about, which again, I didn't put the name, but it's called the first thing is the Articles of Organization. And the second thing is an operating agreement. The bank wants to see your operating agreement. They probably have a form. If you don't have one, they have a form one that they tear off I think they tear off a legal pad and make you fill it out. It's got nothing in there very good to protect you. But it will do if all you want to do is open the bank account. But it's not recommended because there are going to be all kinds of things that should be in there that are not in there. The operating agreement is, other than showing it to your bank, because they're going to insist, but you do not have to show that to anyone else. That goes in a drawer, and no one needs to see that. So yeah, that's going to have a lot of interesting information in it, but that's not to be shown to third parties. There's basically two levels of operating agreement, which is the simplified one, which I can create, particularly if you're a single person LLC, or spouses are owning it. It can be kept very simple, 2-3 pages. An operating agreement, though, can also, and probably should, if there's let's say there's 3 partners, but they're not, they're not spouses, and they're really 3 different people in business together, or more. If there's 3 or more, then the operating agreement also becomes the place to put certain things like what you might otherwise, some of you may have heard of a buy-sell agreement. In other words, an agreement among the owners. Well, what happens if we want to break this business up? What happens if one of us wants to leave? How do we value does that person just have to leave and abandon their interest? They get nothing for it? None of you, right? So that's not a good answer, most likely, right? So how do you set that up is in the operating agreement. Well, that kind of operating agreement, which functions as a kind of buy-sell agreement too, also, and is there forever to protect the partners. Well, I'll call them partners loosely because they're not partners in a partnership, but using the ordinary English meaning of the word partners, meaning you're in business together. The partners, because what are they called really? They're members, right? But the partners, when you're still friends, usually that's the good time to decide how you're going to divide things up. Then right? Because my favorite thing to say when I'm representing people trying to start a multi-person LLC, 3 or more people, I say, sure, this is great, and everybody's out to make the most money we can, and that's great. And I'm sure that someday, 20 years from now, 30 years from now, you're all going to wake up on that same day, and you're going to say, you know what? Today's the day. It's time to get out of the business. And you're all three going to have that same thought on the same day, right? No. People get divorced. People get into financial trouble and need to get out of, sell their interest out, or people move away. I mean, there's a million reasons that come up in life, right? So you have to have, and that's not the time to start negotiating when that's happening. That's not when you want to start negotiating how this is going to work. If you have built in a mechanism ahead of time, when you were all still friends, and the key is, why do I say when you're all still friends? Why is that important? What's important about it, I mean, you all can imagine it, but I'll say it expressly. It's because you don't know who you are in the story. You don't know if you're the one who's trying to leave, or you'll be one of the ones who's trying to stay. So you're much more likely to make a fair, because you might be the one leaving, or you might not. And so the 3 or more of you are gonna work harder to create a mechanism that you now, at least for now, you think is the best and fairest way to divide things up if you have to. It does work. I've seen it work. This talk wasn't intended to go deep into the different kind of mechanisms that there are to do that. There are several. That's the kind of thing you come to see me for. But there are some interesting, I don't mind talking afterward maybe if anyone wants to go deeper, but there are definitely ways to set that up, and that setup goes into the operating agreement. That's where it's got to be binding on everybody, on the members. That kind of operating agreement, this is a little plug for, well, you'll see in a second. That's the kind of operating agreement that takes a while to do. So, like, Roger, is our operating agreement done yet? In other words, that you can't just do that on the back of a napkin. It's going to require layers of negotiation. You do a draft, you circulate it among the members who then have questions, and then you have to answer, it's an adjustment bit by bit until you get to a good document. That takes time. Time translates into money for, when you're hiring a lawyer. So I do want to put in your thought. That's the one place where if you have a multi-person LLC, but it's not unique to LLCs, right? It would be the same problem in just a plain partnership, or just even in a corporation. These issues are not unique to the LLC. What they're unique to is the fact that you've got multiple interests. In fact, in the corporate world, which was much older, remember I said for years, like all through the 20th century, until the very end of the 20th century, corporations were the way to go. Well, that's where the term buy-sell agreement came from, because the shareholder agreement didn't usually have any of that in it. You needed a separate agreement which captured the same thing as I was just discussing. So lawyers have experience with those same issues, but they weren't inside the operating agreement. Instead, they were in a separate document. Generally, it was called a buy-sell agreement. I put some of the other things in there that have to do with financing, because of course we all love our LLC. Well, wait, let me stop a second, because I'm going into a new area. Was that part clear? Okay, about the setup and about the operating agreement versus the articles of organization. Okay. The rest of these are all just some thoughts, in a sense. One good thing about the LLC is some people I know run into a limit where they started out buying things personally, and the bank suddenly won't lend them any more money. Why? Because they have 4 in their name. I don't know if it's still 4, but for a long time, you'd hit 4 and then they wouldn't lend you anymore. Just some kind of guideline that the banks follow. The LLC usually gets around that. It's a business entity. Certainly, if nothing else, it gives you 4 more under a different name. But that's one nice trick. Whose credit? Can you get the bank to finance the LLC without making you liable? Now, that would be a dream. That's very unusual in the beginning, right? Because if you have no business history and your LLC has no business history, they probably won't, well, they won't just finance the LLC because they know that the LLC, it is only liable for the assets that it owns, whereas the bank probably wants you on any lending instrument. So that's why I said, this thing keeps doing that. Am I doing that? Yeah, okay. So that's where I put personal guarantee. How does the bank get around the fact that it's a limited liability company? The answer is usually when you're a beginner, they're gonna make you, sure, they'll lend money to the LLC, but they're gonna make you sign a personal guarantee, which means you're just as liable, but that's just to the bank. You still have the protection of the LLC in terms of everyone else, but you'll probably have to sign a personal guarantee in the beginning. There could come a point where you have so much business and so much history in the LLC that they actually will finance the LLC without your personal guarantee, but that takes, you have to have built up a reputation, I would say. Property as collateral is there to remind me of a story, but I won't, it's probably too deep a story for tonight. But let's just say that if you already owned a bunch of rentals, but you needed to use them as collateral, because suddenly you're gonna buy your first apartment building, let's say, you're going up now a step. You need to borrow much more, and you need more collateral than you've needed before because you're buying now $1 million property. You can at least the LLCs are fairly easy to get them to pledge whatever rental property they own to support your next purchase. And that's allowed. Is Dan here? No, he didn't come. Okay, good. Maybe he's listening, but Dan won't like me saying this, but that's much harder to do if everything is owned in trusts. If everything's owned in trust, that becomes a headache. It can be done, but it is much more of a headache. So it's much easier to get your LLC property sort of to muster them, to kind of pledge them if that's where you want to go. I'm not saying you have to, but if that's going to help you borrow the bigger amount of money to buy your first apartment complex, it's more likely you'll be able to make that happen. So it's just more nimble. It's just more nimble than other forms of business. Now, that's really, in terms of structure, I think I've tried to sell you a little bit on LLCs and how they work and how simple they are. Let's look at I'm going to take a little bit of a turn here and talk about something that is related in my mind to business structure, but it's a little bit of a diversion, but I think you'll see why I want to do it. Everyone good now, though, because I am taking a slight turn. Everyone clear? Any questions at this point? Oh, well, sure.
Our banker said that we should, because we have several different LLCs, that we should just have one bank account that all the LLCs can just, pull the money and stuff.
Well,
because that would reduce fraud, because it would be exposed less to fraud. However, if all the LLCs go to the same bank account, would that increase our liability?
well, I would sure think that any creditor of any one of the LLCs could, if they got a judgment, went ahead and got a judgment, they could reach that money, and they could probably reach all of it. I don't think you can draw any line if you're pooling your money under the. Now, is the account really owned from the bank's point of view by all the different LLCs collectively?
No.
Well, who owns it then?
Probably us as guarantee.
Oh,
Yeah, so it would make sense to keep them separate.
I think so. I mean, yeah. I mean, I've look, when people are new, I've suggested, look, let's not go, don't let don't let perfection be the enemy of good enough, okay? Better than owning, let's say someone comes to me, and this has happened, they have 2 or 3 properties. Now they're looking to grow more, but they own the 2 or 3 in their own name. Put the 2 or 3 in one LLC. If it's all too much for you, just put them in, at least put the 3 of them in one LLC. It's better than your personal name. Yeah, sure, the slip and fall in one probably does open up not just the one property, but the other 2 to possibly being liable, but it's better than you personally. So start simple with one LLC, if nothing else. But yes, eventually we can go there. I recommend a certain strategy with how many LLCs, and I think at the end of the slides I get to that, about how many. But yeah, go ahead. What's the question? That's a good question. No, that's a very fair question. You need to pay attention because the lawyer, what if they forget to, let's say the lawyer doesn't even think about the fact that she or he is your registered agent, or their firm is. Yeah, I mean, eventually, and that would actually be a problem if I'm thinking on my feet here, because I didn't think ahead of that question. That's a very good question. You know, I might want to talk to you afterward, but basically, you want to be aware of whether your lawyer is doing that. You do not want your LLC to sort of, I mean, you do not want your registered agent, if it's an entity, right, I said, if you remember, it can either be an individual or a corporation. If that corporation is going out of business, you do need to pay attention to that because your LLC could get dissolved. It's actually pretty bad if it's uncovered that your registered agent doesn't exist anymore. Same with an individual who died, by the way. It's the same, it's a similar problem. You can't just sit there and let that stand. That gets found out, then the LLC could get dissolved. And then you're looking at the liability yourself. So you do not want to let it sit there if the registered agent either dies because they were an individual or go out of business. That's a good point. And I'll have to think more about how to protect about that, but that's a good point. And it is concerning. Oh, it's easy to fix. It's really easy to fix if you know to fix it, but you don't want to fix it after the lawsuit comes, right? You want to fix it beforehand. Oh, it's easy. It's $10 and the form. Yeah, it's easy to fix. Sure. If you don't know who to do, oh my God, I got to get somebody. If you have to, put yourself in there, but don't let your company get dissolved, because it would. Again, nothing will happen as long as they don't find out, but they can find out. It's, again, too many stories. Well, right. So there are companies that people may have heard of. I think CSC and CRC. There's corporations that take advantage of people, in my mind, and charge something like $350 a year or more to just be the registered agent. And that's a pain in the butt that exists. I do charge a small amount because of just the vigilance I need to have. So I charge much less, but I do charge for it. I used to charge like almost nothing, and I decided because there have been some times where it's a headache. You get served and the headache for me as the attorney is what you guess. The client has moved and never told me, or the client did, so I'm the registered agent and I'm responsible to let the person know, and I have no idea how to find them. That's a pain. It's a risk I take, and then I certainly have to go through whatever motions I need to go through in order to find them. So I charge $150 a year, so whatever that works out to be, like $10 a month or a little more. Like I said, yeah, $12.50, I guess. So yeah, I decided I do have to charge at least something, but that's what I charge. But yes, that's a factor. I mean, right, you might find someone who will do it for free. And of course, you might find an individual. I mean, as a lawyer, some lawyers might do it individually and not charge for it. I just rather use my company, since I'm a PC. All right. Anything else before I go to deeds? Oh, sure.
My mom's helping me set up my LLC now, she works for a law firm, can I put her as a registered agent, no longer individual?
Sure, you can use any individual.
Okay.
Well,
But would that still kind of,
well, that's up to your opinion. What do you think? Do you have the same last name? Yeah. So, I mean, that's just your own personal view of the world. You know, sure, I mean, it connects you somewhat, but not everyone's gonna know that that's your mother, but I mean, but, yeah, I mean, the fact that she works for a law firm is neither here nor there. The individual, I should make it clear, does have to live, has to give their address, and has to be a Missouri address. Same with the law firm. I mean, you have to be you have to have a Missouri address as the registered agent, individual or corporation. But she does, I assume. Yeah, so you could do that. It's free, I get it. And she works in a law firm, so at least if she gets served with a paper, she can say, uh-oh, can you tell me what to do with this? Yeah, I mean, I get it. It's fine, but they might eventually connect you. Just a question for you to decide. Anything else?
Okay, hold on. Got the mic working.
What about insurance problems? I've heard that if you have a contractor work for you and they don't have workman's comp, that your liability doesn't cover it?
Is that Mike?
That's me.
Oh. Workers' comp is a tricky area. If you're using your LLC to do construction, you probably need to obey like all the rules of what contractors and construction, I mean, it's a world unto itself. The answer is, I'm sure you do need workers' comp if you're using your LLC to build houses, and you've got workers working for you. So sure, though, the LLC would be the one liable for if you did it wrong or you didn't have workers' comp. If you don't have workers' comp, the LLC is responsible, and there are penalties for not having workers' comp, which, I mean, there are conditions under which they might be able to penetrate the LLC. They would certainly try. If you break the law, basically, let's say this as a general point, without getting, again, into a whole nother lecture. If you use the LLC to actually flout the law, then there are chances that could result in them being able someone suing you because of what you did, to be able to break through that protection. Because you broke the law and you shouldn't have been allowed to do that. So is that automatic? No, it's not. But is that a danger? Yes, if you're doing stuff that's incorrect. And one thing that would be pretty incorrect is not having workers' comp on construction sites. But yes, I think, is that the question, or maybe?
I'm just talking about handyman, that's not workers' comp, he gets hurt, liability.
No, it does, your insurance might not, but I mean, it would seem like he couldn't sue, he could try. Look, that's the kind of thing where people he might try to sue you, he'd include you and if I were his lawyer, I'd put you and the LLC as defendants in the lawsuit. If you and your LLC, if I'm your lawyer, I'm gonna try to just get the case against you personally dismissed because, he was working for the LLC. If you wanna make that clear, have a little contract in the name of the LLC that you create with him. That would be much, much better in terms of winning that point that he doesn't work for me personally, he works for the LLC. So I would definitely look at that. I would have an agreement with him. Is it perfect? Would it, nothing's perfect, nothing, everything is with the law, any of you who've worked with attorneys have probably, what's their favorite, I know it's my favorite answer, what's an attorney's favorite answer to every question, or the first thing they'll say?
It depends.
It depends, yeah, right.
And maybe you're gonna cover this later, but will you still be able to have privacy with the LLC with the Corporate Transparency Act that's coming in?
Well, I haven't studied the act, so I can't really answer it. So having been asked that question, I will go home and do my homework. But what I would say though initially is I don't see how, I mean, corporate transparency doesn't mean that I don't know where it shows. In other words, I don't know what the act requires in terms of what you have to show and where. I mean,
I only just found out about it today, so
Okay.
it says that it's gonna affect LLCs. I wasn't sure if it was also going to affect
well,
trusts.
that's the kind of thing I'll be investigating, but I don't know right now. It would surprise me that would be a huge change, and it would surprise me. But I'll look at it. Is it a Missouri Act as far as you know, or you think it's federal?
Yeah, it's federal.
Federal.
Hey, Lloyd?
David probably knows about it, he keeps up with
Yeah,
all the laws.
right, yeah. You remember 5 years ago when that Trump 2018 tax law was passed, right? Lloyd didn't bring in an accountant to talk to you guys about it, he brought me in. Because I'm a real estate investor, so I want to know these things and what's happening. Use it. So yeah, Roger, that CTA is horrible. It's a horrible thing. There is no more privacy, even in a trust, Roger. Okay? Even in a trust, all the way down to the beneficiary, they get it all. Okay? Now here's the deal though, it's all gonna go to someplace really safe at the government where no one will be able to get to the data. Okay? So we should all feel very safe about that.
Yeah, right.
But yeah, LLCs, corporations, I don't care how many things you string with a PC and a corporation and everything together, it all comes back to who's the dude that gets the money. And that goes straight to the government and stuff.
Well, that's not good. But I would say that one thing it doesn't sound like it's gonna do is actually penetrate the limited liability. And now everybody knows that I'm the real owner. Okay, too bad. I mean, if that's true, but I don't think the act, because it would really be pointless. I mean, if the act also got rid of the limited liability, then no one will bother making corporations or LLCs or anything anymore. I think now, in other words, it can be known, but you're still got the protection that says that it's the entity that's liable, not you personally. One would think, I don't know, I'll look into it. It sounds bad, but I'll talk next year sometime about it
Yeah.
when I find out more.
I have a question. We often hear people say piercing the corporate veil.
Yeah,
What kind of proper documentation we should have for LLC in order?
well, that's what I was alluding to when the gentleman here brought up his question. There are circumstances, it's not that there's more paperwork that would help per se. Piercing the corporate veil is the lawyer's way of saying, it's like the legal doctrine, whether it's a lawyer or a judge who's trained legally. That phrase triggers in the mind of a lawyer, okay, there are circumstances where something so egregious is being done in the name of the company that it's like wrongful or against public policy or some such phrase that the person should be allowed to do that and still get the protection of a limited liability. So really what it comes down to is if you did something very illegal or very egregiously violating other people's rights, there can be circumstances that they would be able to pierce the corporate veil. The other well-known, like no-no that leads to that is the person who uses whether it's a corporation or a limited liability company or any other entity, if you start using it like your own piggy bank, then you're definitely destroying that. I mean, that's by far, if I want to attack the other side's, like I want to pierce the corporate veil, the best thing I can find is the day they pay all their bills using money out of the LLC bank account. They take trips and they have a business credit card, but they put everything on there. Their Netflix and Amazon and everything's on the business credit card. Well, at a certain point, that means that you're treating it as your own back pocket. So that a lawyer can very easily argue that, okay, it's just an alter ego for you, it's really you. And that'll be a successful argument in court. if you just use it as your own piggy bank. So that's the single biggest, most frequent mistake. Don't do that. Don't buy, don't have the LLC if you're gonna do that, because there's kind of no point. Do not pay your personal bills out of the LLC. Pay yourself, take an owner draw and use that money, and that's taxable income. By the way, the good news about that is it's taxable at ordinary income tax rates, but there's no employment tax on that money. And there's no FICA, so yes, you'll pay, you should report it and it's ordinary income to you. But don't, take the money and then pay your bills with it, but don't pay the bills directly with either credit cards or checks in the name of the LLC. Make sure those are just business expenses.
So is that something you regularly see or rarely see? Just other people talk about. Here's the
Well, because it's the big thing that people are afraid of. And because it kind of wipes out the point of the LLC. It's usually because someone's being sued or about to be sued, and that's what they're afraid of. Oh, it's real. Is it frequent? I would have a hard time giving you like some kind of statistic. But you can count on the other side. If you've done something, you can count on the other side's lawyer to try. They're going to try. Because what do they know up front? They don't know anything up front. They're going to do what's called discovery, they can make you turn records over and stuff like that, and eventually if it becomes clear that that's what you've been doing, then they're going to go for that. They're going to go, and it's, again, the most frequent problem that leads to a court actually agreeing with the one side that wants to pierce the corporate veil of the other is because they treated it as their extension of themselves. Only rarely, it's very rare. The other example I gave is extremely rare. It's very rare that you see it because the company or the corporation did something illegal. That's true, that could lead to it, but that in practice doesn't happen so much. But what does happen is people they kind of ignored it themselves. They were treating it as just a cash funnel for their own expenses. And you don't want to play that game, because then you're destroying the point. And yes, that does happen. So I don't want to go, Lloyd, do I have time for more? Am I running too late here?
Oh, no, you have plenty of time.
Oh, okay.
Ann's got something.
Yes, this might be an outlandish question, but do you?
Ridiculous, never mind.
Do you feel that eventually AI is going to take over and we're going to, if they will be able to, I guess, tap into anything, we won't not have any protection at all? How do you feel
I don't
about
know. AI is likely to make my job sort of gradually make it more and more obsolete because people will write their own briefs. And,
Right.
Based on precedent, the AI can read every brief that ever was written on the same subject and then put together a composite. But I don't know that AI alone, it's AI combined with whatever Amanda said. It's not AI as such, it's AI combined with some stupid act like what she just told us about. The combination it sounds deadly. Because if the law isn't going to be that you've got to reveal all that, I don't even understand that law, because where are you going to reveal all that? You're going to walk around with, have airplanes in the sky with banners? What does it mean you're going to reveal all that? We don't need to go there. I can find out and give a talk on it, in February or January or March, and figure out what it really does mean. But it sounds kind of crazy, and so I'll have to see. A lot of things, all I know is that in my career as a lawyer, a lot of things where people said the sky is falling, it turns out after a while that there's ways around it or there's ways to deal with it. One good example was in Florida, they started impounding LLC. I say that this is too complicated probably for this talk, but I'll touch on it for this reason. It was like this terrible, terrible thing that you could get a charging order and then you could actually charge the LLC for something they're suing you for, so it sounds like you're losing the protection. Oh my God, the LLCs are useless now. It's not how it's played out. There is the problem that if you are the sole owner of an LLC and someone is your creditor, they can't go into the LLC as such. That's what people didn't realize. It didn't change that. But in some states like Florida, courts would say, well, what assets do you own that could satisfy this judgment? There's a judgment against you, let's say personally, for something. Well, the LLC has a value. They can't look inside the LLC. They can't, at least they couldn't until that happened, maybe. They can't attack it by piercing it, but they can just say, hand it over. It's an asset, you own it. You owe me a lot of money. I'll accept your LLC as full payment for those debts. Thank you very much. Well, if that LLC owns a bunch of stuff, that's where it could get a little tricky. Now, not all states will let that happen, so that's a little complicated. It's not easy to do that as the plaintiff, but that's what a charging order could lead to. It's very rare, and I don't think it doesn't work in Missouri, but it might work in Florida because there was this very controversial case. But it hasn't played out that way. In other words, people still use LLCs in Florida, and it basically works. The other answer is as soon as there's more than one member, and that's another thing. What people started doing in Florida is, okay, I'm going to give a 5% interest to my cousin, and now you've killed it because it's not just you. It's not yours to hand over anymore. Oh, there's another owner. So now it's not there for your debts. You can't hand it over because there's other people. So the simplest people were doing that a lot as a simple way to solve that problem. But I've never seen it. You can't even, it's not available as a remedy in Missouri anyway. But that's an example of the sky is falling. Everyone thought LLCs are going to be useless now, and it wasn't that hard to fix. So I don't know. That's all I'm saying is we'll adapt as things go crazy as best we can, right? I mean, yeah, I mean, you can go. I know in Catron County, is it New Mexico? Yeah, Catron County, New Mexico, which is bigger than some states, runs the whole west side of New Mexico. There's people there who live, there's a couple little towns, but you go deep into the hills there, and there's people who live in the entrance of what looks like just a cave, but when you go in there, it's very fancy and very plush, and they've got enough supplies to last for 30 years stored away. So you can do that, right? And go off the grid. I mean, these things exist, and some people are that worried. So what can I say? Anything else? Should I advance to the next thing? I think so. So Jim says yes. So the next three slides, I'm going to quickly show them to you, and then I'm going to go back, and I'm not going to go into so much detail as it seems here, because I think you're all familiar with. First of all, you understand that property transfers by deeds, right? And I'm bringing up deeds because they play into the structure. They play into how you're taking title by a deed. It has an interplay with, well, are you taking title as an individual? Are you taking title as an LLC? Are you taking it as a corporation, or what? Who is deeding it and who is receiving it? Who is deeding it out, let's call it? That's deed. When I say deeding it, that's usually the person selling it or deeding it to the other person, but that's how we talk, right? But sometimes it's not clear, like the word rent, I hate as a lawyer, I have, rental, it's a rental, but are you the tenant or the landlord, Okay. Oh, here. So the three slides are three types of deeds, right? You've probably heard of them all. The tricky part about understanding deeds is the easiest deed is the quitclaim deed. Now that's actually, I had that as the third of three slides, but I'm thinking now I should start with that one. First of all, I can teach you all a quick lesson because half the world calls them thinks they're quick claim deeds. Just do me one of them quick claim deeds, right? it's not a quick claim deed. Quit, in kind of older English, means essentially, think of it as relinquish. To quit your interest in something was to relinquish your interest in it. It's similar to the way we use quit in ordinary talking, similar but not the same. Now, you quit means you quit playing, which means you no longer have an interest in that game. So,
It's like you think
keeps
what you're talking about.
jumping on me.
You don't do that side of it.
I don't know what I'm doing. All right, thank you, though. Thank you. So, oh, yeah, let's go. So quit claim deed is, that's your, but see, that's, what's nice about a quit claim deed is all you're doing is relinquishing whatever interest you have in XYZ property. What if you don't have any interest in that property? You've not done anything illegal. Keeps doing it, doesn't it? Oh, yeah, escape. You've not done anything illegal by giving, I can give you a quitclaim deed, you know, the famous example to the Brooklyn Bridge. Have I done anything wrong? No. You have, now you have whatever interest I ever had in the Brooklyn Bridge, which is nothing. But there's nothing, okay, that's the truth. You don't have anything, but I didn't do anything wrong by quitclaiming it to you. Just, I don't have any interest in that. What it does do, though, is if you do have an interest, if I do own a piece of property and I quit claim it to you, then I am conveying it to you. It does work. It is a deed. So it is a deed that will transfer property. What it doesn't do is it doesn't guarantee you about what the status of my interest really is. So if it turns out that I told you that you'll own this property, but it turns out I don't have an interest in that property, there was no guarantee in the quitclaim deed that says I did. So you really can't win on a suit back on somebody who quitclaimed you the property because they didn't make any warranty of title. They didn't say that they didn't literally, by the fact of the deed, tell you that we own this. Again, they're really just saying, if I own it, now you own it. Right? So that can be a problem. What if I don't own it now, but I do own it, I'm negotiating to buy it? Well, that's not a crime in itself. I can sell you something, if I'm honest about it, that I'm still negotiating to buy. I can sell it to you today. As long as you know that, I'm not committing a fraud. A quitclaim deed, though, you shouldn't, if you're the one accepting that, you shouldn't do that with a quitclaim deed, because now, if I get title after I quitclaim it to you, you don't automatically get the title. Now, that's the difference. Let's go back now. The general warranty deed, which is what you see, you know, when one homeowner transfers to another in a vanilla flavored residential real estate home transaction, where one homeowner has lived in the house for 20 years and is now moving to take a better job in Georgia. So there they go, and now they're selling you their house. They'll do it by general warranty deed, which is a guarantee that they did have title. So in my scenario, then a general warranty deed would work if I said, well, you know, I'm still negotiating about this, but if you'll buy, I still want to enter into a contract with you to sell it to you. That's actually okay. If I do get title, now you have it. It automatically goes to you if I gave you a warranty deed. Special warranty deed in general are basically the same for the purposes of our purposes as investors. The special, if you ever do want to give guarantees of title, though, don't do the general. Do the special. If you're the one conveying, if you're the one selling, do this. If you want to give some kind of guarantee, do the special, not the general. Why? Because the special only says that nobody has superior title to me. No, that's not the point. How do I say it better? A special warranty deed only says that while I owned it, I didn't put any other liens on it or let any other liens get on it. So as far as my activity with this property, it's a clean title. But I don't know anything about the ancient history of this property. I'm not guaranteeing that there's not some very old lien of some sort that I was subject to and now you are, if I only give you a special warranty deed. It only is a guarantee that I don't owe other people money and I didn't pledge this property as collateral, or I didn't do other things the word that lawyers use, and most of you've heard it, is encumber the title. That means let a lien be put on it, pledge it as collateral, and so on. So its special warranty deed says I didn't do that, but it doesn't guarantee the chain of title going back forever. So the strongest one is the general. So receiving the one, if you can possibly get someone to give you a general warranty deed, that's the best one to receive. To give, of course, quitclaim is the one that is the least, causes the least potential problems for you. So, but the point is, if again, as a general, giving a special warranty deed as an LLC is safer, right, than giving it, and that's why I think the two topics kind of mix at this point, is if you could maybe give a special warranty deed because your LLC owned it, and you know your LLC's clean. That way you don't get your own name involved in it though. It's only your LLC that's saying, yeah, the LLC did not put any extra liens on there. So you see, the LLC combined with the right deed can tell you is a useful tool. And that's kind of why I put it in here. I mean, there's plenty else to say about deeds, but that's, see what I said, warrants defects during time of ownership, or no further encumbrances during grantor's possession. That's what I'm saying. So that's the special versus the general. But again, a quitclaim makes no guarantees about the title, and yet it does convey the real estate if it's true that I do own it. It is effective. It just doesn't have any guarantees. I want to mention other types of deeds just to teach, because you're all investors, or looking to be. There are some interesting other types of deeds that you should, again, as a lawyer, I just sort of want to put that. As a real estate lawyer, I do a lot of these different things. So this is a little bit of a side point, but a beneficiary deed, remember I said that your LLC can have a transfer on death provision. Is there an equivalent for real estate? When we can put TOD, right, on a car title, we can put TOD most times on a bank account, right? Transfer on death. So no probate, right? It goes straight to the person. You come into the bank with a death certificate now, it says transfer on death, that's it, you're done. Same with the title of a car. A beneficiary deed can do the same thing for a piece of real estate. So you don't have to worry about a will or putting it in trust for you just do a beneficiary deed for whoever you want to receive the property on your death, and it's really simple. You just file the affidavit of death, and the beneficiary deed is already on file, and now it's your property. And you didn't go through probate or anything. You also get the stepped up basis on death, and I will explain that to anyone who asks me afterward. But it works just as good as getting it in a will or in a trust. Go ahead.
So then,
what does it cost, a rough estimate to set up a beneficiary deed?
Oh, I do them for about $150, and then you filing fee in the real. I mean, you need to pay another $50, maybe $40-50 to file it.
Oh, okay.
So 200-ish altogether. Yeah, they're not. I say that if you've got some weird real estate, or you're doing that on 10 different pieces of property that I have to put the legal descriptions. It could cost more if it takes me more time, but a basic one for one property that's a simple, straightforward beneficiary deed, one beneficiary, I'd say I'd stick to that.
Just one house, it's just one house.
One house and one recipient.
Or well, two recipients, but
Are they married?
no, brother and sister.
Okay,
I'll talk to you later
Yeah.
about it.
okay. Yeah, two recipients, we doubled it, 300, right, okay. No, it's a good instrument. Important though for your recipients to understand something, since you did ask an extra question about it. This is your bonus for asking a question. beneficiary deed does, let's take your example, you do it and it's for who?
For me and my sister.
Oh,
My mom's house.
or your mom might do it to you and your sister, all right, let's say, all right, for example, don't get confused about one thing, it doesn't, even though it's sitting there in the record now, it's filed for record in the recorder of deeds office, it does not prevent her from selling it. It only means that if she still owns it when she dies, then you get it. But if she sells it, it doesn't, you and your sister have no ability to claim across and stop that sale or later do anything about it. By selling it, she effectively canceled that beneficiary deed. And you, the recipients, can't stop that from happening. So just know that that's true. It works, but doesn't stop the person who did the beneficiary deed from deciding, oh, you know what, I'm gonna sell it instead. But there's a good side to that, which is it means the person is less afraid to put one on their house because, okay, if I do die, I want my kids to have it, but if I'm gonna retire and need to move to Florida and sell it, it's not gonna get in the way. Yeah, so it's useful. There are deeds by trustees from a trust, that's obvious that there should be such thing. Don't confuse that though with a trustee under foreclosure. A trustee's deed under foreclosure is the title you'll see on a deed when there's been actual foreclosure. And the trustee is the person who had the power under the deed of trust to sell the property to pay the debt. So that's a whole it's the world of banking, right, and liability. So it's just something to know. It's called a trustee's deed under foreclosure means it was just foreclosed on. That's what so if you're getting the property that way, it means you bought it out of foreclosure, and that's what the deed would say. Personal representative can sign a deed. That's if you do go to probate. Someone gets appointed personal representative because the person didn't have a will and they didn't do anything else, and you're one of the heirs at law. Well, there'll be a personal representative that has to sign that deed, or a conservatorship. Again, that's if somebody's incapacitated and they go to court, someone else, a relative, goes to court and says they can't handle their own affairs, please appoint me conservator, then the conservator could sign a deed for that person. But that's also could be valid if the conservatorship was done right. And then a sheriff's deed, that's when they sell your property for debts. Again, I won't go into, there's a million situations that could lead to that, but there could be sheriff's deeds. So those are a bunch of different types of deeds. Okay, special topics. Oh, was the deed part, anyone have any questions on deeds? Because I'm kind of done with that.
The last one, the sheriff's deed,
Oops. Yeah.
is that generally issued after you buy the house from a tax sale? Is that the type of deed, or?
Yeah, I guess that is another type of sheriff's deed, yeah. But wasn't what I was thinking of, but those are generally sheriff's deeds too, that you have to quiet title to turn into insurable title. So there's a whole story there. It's another talk.
Sorry.
But yes, after you purchase the tax lien at a tax lien sale, what you'll get is a sheriff's deed. There's nothing wrong with the sheriff's deed, but title companies won't insure them unless you've also done what's called a suit to quiet title. Another whole talk. But yes, it happens to be a sheriff's deed also. One thing that people don't know, question?
Yeah, you said that for an LLC, it's going to be a special warranty deed on the property.
Rather than a general,
Right.
yeah.
But if you go through the trouble of paying for a title search, in general.
You could, if you're comfortable. If you're comfortable that your title search was a good, which you should be, right? And you've got good title through a title company, and there is nothing in the history that you to be worried about, then that would be a reason why you could probably convey by a general warranty deed, because there's nothing there, and you have a title policy to back you up. If it turns out to be wrong for who knows why, the title company's on the hook now. They've given you title insurance. That is the point.
And then you have to pay for the title.
Yes. Yeah, oh yeah, yeah. But it has a value. If you don't finish quieting the title, you still own the thing, but, you know, we should talk, because I know you need a title finished, and I'm aware of it. But, there's yeah, I mean, you need to quiet the title in order, it's not really that you need to. In other words, there's nothing wrong with the fact that you have a sheriff's deed, but to be comfortable, for anyone to be comfortable buying it from you, is when that will come up. There's nothing wrong with waiting a bit until the sheriff's, but again, the point is gonna be to sell it, right, fix it up and sell it. Yeah, you need to have quieted the title. What? Well, you mean to try to refi it? Yeah, well, the bank will probably hesitate also, again, until you quiet the title, right? I realize. So, he's aware of a property that we need to finish getting done, so, that's, yes, we need to finish it so you can either refi or sell, yeah, understood. But that's, the sheriff's deed can also, one thing that a lot of people don't know that I've run into more than, you asked about the frequency of certain strange things, like piercing. A thing that people don't know until they find out the wrong way is that your homeowners association is usually given by law very strong powers. You can kind of understand the origin of it, right? Because they don't really have a lot of money, right? They usually, the HOA fees are not a big, I mean, they might be several $100s a year, but they're not huge money. I think that's the origin of it. I don't really know why, but that's my guess. So they're given some strong extra powers that the average association, you wouldn't think they would have. One thing they have is the power, if you get behind in your HOA fees, I mean, they wouldn't do this, you would hope, if it's just 1 year you're missing or 2. But I've seen situations where someone hasn't paid their HOA fees in 5 years or more. They have the power to foreclose on your property. So let's say you're talking a $500 a year HOA fee. So after 10 years, you owe $5,000. They can, and your house is worth $300,000, let's say. They can foreclose on your property, sell it on the courthouse steps, take the $5,000 that's theirs and give you the balance, which won't be $300,000 on the courthouse steps. So, and that would be a sheriff's deed, because that sheriff is who, when they do that, that's who's selling it. It's a sheriff's execution. That'll be a general execute. That'll be an execution by a sheriff. That's what they'll go to court and they'll get the right to do that. So don't ignore your HOA fees, okay? They have an extra superpower to get their money back. But I actually have had to fish people out of that fire a couple of times. Yes, people don't know. So see, I do all kinds of things as a real estate lawyer that you probably never thought of. Here. So we've covered the privacy thing pretty well. And I also covered these are reminders to me, more or less. And the probate inheritance, again, is just the point that people don't realize you can put something in the operating agreement that makes the LLC transfer on death. Tenant relations was just that almost, I was being a little humorous, right? But what I meant by that was like, again, I'm just the manager, what do I know? I'll have to talk to the owners about getting that wash machine replaced, or something. So it puts a layer of separation between you. I think it's true to some extent, right? If you really own it personally in your name, there's no hiding that you're the landlord, right? But it's an LLC that owns it, and I'm the manager of the LLC. Even if you don't make a big deal about it, it just puts a slightly different feel on the whole thing. Now, LLCs and evictions is the last serious topic I wanted to get into. I'm not going to read you this. These are more in a way for me, but to remind me what to tell you, because I don't expect you to be able to read all that from out there. But let's just say there are two main types of lawsuit, and those of you, anyone here, who are the landlords here who've had to evict people? Okay, a number of you. And are you aware that there's two basic types of lawsuit, and why that is, and there really is a third one that's also, I'm gonna mention it, but there's two main types. Do you know what they're called? Who here knows what they're both called? Correct. So when does rent and possession apply? Versus, why would you pick one over the other? When does rent and possession apply? Well, yeah, but that could also be unlawful detainer under some circumstances. Well, no, but why would you pick rent and possession over unlawful detainer? I couldn't quite hear you. Well, you can get but either type of suit, you get both. So the trick is, if there's a lease that's still in force, and you're not out past the end of the lease either, then it's rent and possession. And rent and possession tends to be a little quicker. If the person is not, you got a lease, or they had a lease, but you let them stay and become a month-to-month tenant, you let them stay past the end of, let's say you had a 1-year lease, but now they're there past 1 year and you never renewed the lease. Now they are a month-to-month tenant by law. There's certain rules that apply to a month-to-month tenant who doesn't have a lease. There's certain specifics, like how much notice you have to give them if now you want them out, right? Because there's no lease, right? So you should be able to get them out, right? But there's rules about how much notice you have to give them. Where'd that go? Oh, yeah, here. So the trick that I want you to take away from all this is that you have to make an unlawful detainer. So that's if you've got a month-to-month, or, and this is another thing, if it's after a foreclosure, right? Is that what it's? Does it say that clearly? Should, or is that, wait a minute. Thought I underlined it. Right, it is, that's what that says. Second bullet point is, it's an unlawful detainer case after a foreclosure, but it's not an unlawful detainer case after a tax lien purchase, which is a lot like a foreclosure. But when you buy the tax lien, it's a more complicated kind of lawsuit to get them out. It's not rent, possession, or unlawful detainer. So the tax lien is a pain in that regard. If you want to try to evict them, it can be done, but there's a third type of suit called ejectment, and it is not on a fast track. Unlawful detainer and rent and possession are supposedly, at least, on a faster track in Missouri courts. And that works, of course, with a tenant, and also under rent and possession, and also with unlawful detainer after either they're like a month-to-month tenant, there's no lease anymore, or even after an ordinary foreclosure. I'm talking about like a foreclosure because they didn't let us, like when the bank forecloses. After a tax lien sale, it's even a slower case, and it's called ejectment. That's like if you're trying to eject a squatter. They just showed up somehow on your property. That's a whole nother deal. It's even takes a little longer. Which seems strange, right? The person who had no right to be there is harder to get out than the person who actually came there with a lease, had a right to be there in the beginning. You would think that would be the other way around, right? But go figure. I can't even explain that as a lawyer. But here's the part I want you to, and I know there's other lawyers that people use in this room, and they're good lawyers for especially, by the way, I don't do tons of evictions like some lawyers you guys probably know the names of, which I won't do them any free advertising. But they're good lawyers, but sometimes people aren't aware of this. You must give notice first. And I have actually, sometimes tenants will come to me, I mostly represent landlords, but if a tenant has an honest case, I don't refuse it in principle, I mean, it just doesn't happen a lot. They don't want to spend the money, and so forth. Oops. There it is. But if you don't give that notice, I have actually, well, that didn't work, video escape. Did more than get rid of that Mike Patchen. Let's try it again. Point is, you have to give that notice, and that notice, if you don't do it, and I'm representing the tenant, I can get the whole case thrown out. You got to start over. So that notice is important, and after foreclosure, there's specific wording in the statute of what that notice has to say, and it has to be done right, and it has to be served and posted. You have to get a private process server sometimes to serve it. Without worrying about which is which and which detail goes with which kind of suit, but that notice hangs people up, and a lot of people are sloppy and they don't do it. And of course, most tenants don't hire a lawyer, especially a lawyer who knows what they're doing. So a lot of times they get away with it. I mean, I understand that. If the tenant doesn't know to raise that issue, hey, I never got a notice, and that's a really actually important issue, they don't mention it, and whatever, right? Or they didn't get proper notice. So that's what that was about there. Notice required. And I like this example. I have actually an attorney working for me who does the majority of our evictions. And I took a letter that he wrote, and then I just changed the names to neutral names, right? So I figured this would be cute. It's from the Pitbull Law Firm, and the lawyer's name is Fearsome Pitbull. And he's writing to the, notice though, he's writing to the tenant, right? Writing to tenant 1, tenant 2, John Doe, and Jane Doe. Very important to add in because don't know who's good, right? Maybe there's other adults living there. But it's all right if you want to put one each. That covers however many men and however many women live in. But you have to put each one together because what if tenants belong to one city, or you also have other adults, including the adult children. So that is a thing on the line. And that's where there's one off between the four, a little different. The notice would be, you need a notice for both of possession and thing. Now, another thing you can see that surprises me, but not really, but don't do this. Take one thing away, if you are a landlord here and you need to evict, do not, when you're writing the letter that says you need to get out, and you don't want to hire the lawyer yet, I get that. Don't spend money on the lawyer, but here's one thing, please don't do this. Do not say, do say, okay, you haven't paid the rent in 2 months, 3 months, whatever, please be out by the end of this month, or pick another date, whatever. You're in breach of your lease. Do not say, I am terminating your lease. I see it all the time. Because it sort of sounds logical, right? Like, I'm terminating your lease. That should terminate your right to be there, right? No. What terminated their right to be there is that they're in breach of the lease. They didn't pay the rent, which is required by the lease. Or they did something bad. By the way, you can also evict people for other breaches of the lease, right? Like, you can put in there that they're disturbing the neighborhood, and that can be a requirement in your lease, and if they're doing that, that's another breach of the lease. Don't terminate the lease, because the lease has things in it that you want, such as, what's the biggest one? The lease will most likely say that in the event the landlord has to sue you to get you out, the landlord not only gets the rent, but is entitled to his, her, or its attorney's fees. If you terminate the lease, you just terminated the thing that would have given you attorney's fees. So you'll still win, most likely, right? I mean, because you're right, they didn't pay you and they're in breach, you know. But now you can ask for attorney's fees and the judge says, well, you terminated the lease, so. And if you don't have a lease that says you get attorney's fees, you don't get them. So don't terminate the lease if there is one. Now, if it's unlawful detainer and there's no lease, it's a different problem, right? But don't terminate the lease. And unlawful detainer, please send the correct notice, you know, because the statute for unlawful detainer has exact wording for how you have to word that notice. And you must send the notice first. And I think there's a certain number of days ahead of time. Yeah, that's the other thing. Unlawful detainer has like something like 10 days. Rent and possession, that's another thing. It's better, why it's better. Because you rent and possession, you have to give notice, but there's nothing prescribed about, in other words, you could give the notice and the next morning you could go file a lawsuit to evict them. You just have to say in the lawsuit that you did give notice. It doesn't say how long ago you gave notice. The unlawful detainer statute, I think, says 10 days. Anyway, it has a definite period that you have to wait, and then you can bring the lawsuit. Why did I put this in here? No, there was a good reason, I'm forgetting it. Oh, of course. This is the other big takeaway for today. And now what's probably the only bad, I think in my view, this is the only bad thing in a way about an LLC, but it would be equally true about a corporation or any other, a trust, anything else like that. What's the one bad thing in a certain way that I'm thinking about here when I put this slide up here? Anyone know what I'm getting at? Can you read it? I don't know if you can read it. You cannot personally represent the LLC in court. You cannot file the case in court. It's true that if you own it in your own name, you can go to court and you can file that eviction, and there's nothing wrong with that. That's the one, I have to admit, it's a bona fide, genuine, like, advantage, if you will. To me, it's not worth, you know, all the other negatives, but it is an advantage that you can sue on your own if you own it in your own name. If you own it in the name of an LLC, or I don't care, or an LLC or any other entity, any other thing other than in your own name, you cannot represent that entity. Not only that, but you're committing a crime. It's called, see, misdemeanor in black. It's actually a misdemeanor, so it's a low-level crime, but it's technically a crime to file something on behalf of your LLC when you're not a lawyer. That used to be, clever lawyers for a long time used to argue, well, Your Honor, it's a misdemeanor, but that's for the prosecutor to do something about. But meanwhile, you know, my client here, yeah, he filed the suit on his own, we know he shouldn't have done that, but now he's got a lawyer, and he's not going to go forward on his own, and we understand. So that should take care of it, shouldn't it? You bring the lawyer in later. Well, that used to be done a lot. No, in court. Court is the key. Only court. Filing in court or appearing in court. But now you can change the lease and draft stuff. Yeah, not required to be a lawyer. No, but if in court, you can't file on behalf of it, and you can't show up in court and argue in behalf of it. And here's the relatively new thing, in the sense that there was a case only about 3 or 4 years ago that clarified this point. And once there's a case, as I mentioned way in the beginning, precedent is a big part of the law. The case said, yeah, it's very nice that Mr. Wallach, let's say I'm trying to argue that. Yeah, my client should not have started this suit on his own, but here I am, Your Honor. Yeah, it's a misdemeanor, but my argument before that case would have been, yeah, so the statute says it's a misdemeanor, so that's what the legislature intended. They intended, the sanction is that it's a misdemeanor. Someone should tell the prosecutor and go ahead and whatever they're going to do. But when the statute says that means it could have said, well, also everything you do on behalf of the LLC doesn't count, but it doesn't say that. Well, there's a case that basically, again, without going into all the details of how they got there, now it's very clear that not only is it a misdemeanor, but that's rarely, I've never seen it, anyone actually prosecuted ever for that, and I doubt they will be. Because the other sanction is much more important and much more damaging. Everything you did on behalf of the company in the courtroom from the filing of the suit forward is wiped out. It's a nullity, like it didn't happen. That means that you've got to start all over with the lawyer, with a new lawsuit and a new everything. And if there's other things going on where time is of the essence, you're losing a lot of time, right? Starting all over. And I can tell stories about where would time be really super critically of the essence is, again, there's complicated situations, but let's just say if there's any bona fide real disputes about title, you want the unlawful detainer to go quick if your title is being challenged in another courtroom. But if that just happened to you, because you went ahead and thought you were going to be clever and filed a lawsuit on your own, it's like do not pass go, do not collect 200. You're going right back to the beginning and you're starting all over. So you've lost a lot of time and whatever money. But that is now that's why it's unauthorized practice of law to file the lawsuit or to go to court on behalf of your LLC or any other, for that matter, for a corporation or for a partnership or any other entity other than yourself personally. For yourself personally, it's totally allowed.
Okay, do we want to take,
I think that's, yeah.
last question?
No, that's it. That was my final point that I wanted to leave people with.
Okay, thank you. Anybody, any last questions? Or sure, Roger, you willing to stick around?
I don't mind just.
We got the room for another half an hour.
Right, I don't mind staying around and answering
Is any-
individual questions if
Okay,
that's better. But anyway, I hope all that was of some interest and use to people here.
very interesting. Thank you.
Thank you very much.
We appreciate you coming out tonight.
And although I'm happy to give you a card, but my contact info is on.
Contact information. Okay, and you've got cards with you?
Yeah, I do.
Okay,
Sure, I
okay.
do. Yeah.
Okay.
Okay.
Okay, that'll do it for tonight, and just a few parting comments. A lot of us are landlords, and we know how our tenants, when they leave, we like them to take all their trash with them. And right now, tonight, we are tenants in this room, so our landlords would like us to clear our tables, throw our trash in the trash cans nearby. There's a couple trash cans around. Appreciate it all. And just remember, see you next month but we're not in this room. We're going to be upstairs. Take the elevator over on this side up to the 3rd floor. We'll have that posted on our newsletter. And thank you all for coming. See you next month.